Picture this. You're Sarah, an American who fell in love with David during a semester abroad in Tel Aviv. After a whirlwind romance and a beautiful wedding, you're navigating Israel's immigration system to get your spouse visa. The paperwork is complex, the bureaucracy moves slowly, and suddenly your tourist visa expires while you're waiting for PIBA to process your extension request. Congratulations, you've just become an illegal dweller under Israel's proposed new cooling-off law, and now you'll need to pack your bags and live in exile from your husband for at least 1 year before you can even apply to come back. On July 16, 2025, Israel's Minister of Interior unveiled this masterpiece of legislative overreach disguised as immigration reform. The law promises to solve the problem of illegal immigration by introducing a punishment system so severe it would make Dickensian workhouses seem welcoming. Anyone who stays in Israel illegally for more than 30 days, yes, just 30 days, becomes an illegal dweller and must leave the country for a cooling-off period that ranges from 1 to 5 years, depending on how long they overstayed. The beauty of this system lies in its mathematical precision. Stay illegally for 31 days to 3 months, and you're banned for 1 year. 3 months to 1 year gets you 2 years of exile. 1 to 3 years earns you a 3-year separation from your family. And if you've been unlawfully present for over 3 years, congratulations. You've won the grand prize of 5 years away from your spouse and children. But here's where the story gets truly Kafkaesque. That 30-day threshold isn't just arbitrary. It's practically designed to ensnare law-abiding people. Immigration processing delays are routine in Israel, especially during periods of political upheaval or security concerns. Visa extensions can be delayed for months due to backlogs, staff shortages, or simple bureaucratic incompetence. Under this new law, every couple navigating the system becomes a potential victim of circumstances entirely beyond their control. Consider the case of Maria, a Spanish woman married to an Israeli citizen. She submits her visa extension paperwork 35 days before her current visa expires, following all the proper procedures. But PIBA is experiencing delays due to a computer system upgrade that went wrong. By the time they process her application, she's been technically illegal for 45 days. Under the new law, she's now an illegal dweller who must leave Israel for 1 full year before she can even apply to return to her husband. The lawmakers behind this bill have thoughtfully included some exceptions for error in good faith, circumstances beyond the foreigner's control, or humanitarian cases. But these exceptions will be granted at the discretion of the Minister of Interior, creating a system where fundamental rights depend on bureaucratic mercy rather than legal standards. It's like being told you can appeal a parking ticket, but only if the traffic commissioner feels like being nice that day. The Supreme Court has repeatedly ruled that forcing foreign spouses of Israeli citizens to leave the country as a condition for status legalization is unconstitutional. The right to family life, the court has said, outweighs administrative convenience in preventing illegal immigration. But the new law essentially tells the Supreme Court to take a long walk off a short pier. It's legislative defiance dressed up as immigration reform. Even more remarkably, the law attempts to eliminate judicial review entirely. If someone is denied entry while still in Israel, any appeal or petition won't be heard until they leave the country. It's a brilliant legal maneuver. You can challenge the deportation order, but only after you've been deported, when mounting an effective legal challenge becomes virtually impossible. It's like being told you can contest a race result, but only from the parking lot after everyone else has gone home. The legislation does include a grace period for couples already in the system, but only for heterosexual married couples who submitted applications under Section 7 of the Citizenship Law. Unmarried couples and same-sex partnerships are left to fend for themselves, because apparently some families are more worthy of protection than others. This cooling-off law doesn't exist in isolation. It's part of a broader pattern of legislative hostility toward international couples in Israel, including M.K. Rothman's proposed Basic Law on Immigration. Together, these bills represent a systematic attempt to make family reunification so difficult and risky that people will simply give up trying. It's deterrence through bureaucratic brutality. The human cost of this policy is staggering. Thousands of families could face forced separation for years over minor administrative infractions. Children could be separated from parents, elderly relatives could be cut off from caregivers, and established lives could be destroyed by bureaucratic delays that turn routine paperwork into criminal infractions. The proponents of this law argue it will strengthen border control and deter illegal immigration. But the reality is that it criminalizes the victims of bureaucratic dysfunction while doing nothing to address the root causes of immigration violations. It's like solving traffic congestion by banning cars, technically effective, but missing the point entirely. The bill is currently in its public comment phase, with opponents racing to submit objections before the August 6th deadline. From there, it will move to the Knesset Interior Committee, which is currently chaired by a member of the far-right Otzma Yehudit party, and has shown consistent hostility toward international couples. What we're witnessing is the transformation of administrative inconvenience into criminal punishment, the elevation of bureaucratic efficiency over human rights, and the systematic dismantling of judicial oversight in favor of ministerial discretion. It's a masterclass in how to destroy families while claiming to protect national security. The international community should pay attention to this legislation, not just because of its impact on thousands of families in Israel, but because of what it represents. When democracies begin treating minor administrative violations as crimes deserving years of family separation, when they eliminate judicial review and concentrate power in ministerial discretion, they set dangerous precedents that extend far beyond immigration policy. The cooling-off law is more than bad policy. It's a fundamental challenge to the principles of proportionality, due process, and human dignity that underpin democratic governance. And if it passes, its effects will reverberate far beyond the couples it directly targets, reshaping Israel's relationship with basic constitutional principles and human rights.